Good afternoon, everyone. We'll start the session in time. So this is another session on medico-legal aspects in our field.
Two talks you can do. Two.
Only one. 10, 15 you can take. No.
10,
15,
15.
15. So the awareness on medico-legal aspects is needed, and it is increasing in our community. Usually whenever there is a legal notice, all of us get totally frightened, and we don't know how to react. So all these instruction, there are at least 5 instruction courses on medico-legal aspects in this conference. This will help you to stay calm when you get a legal notice, and you should know what are the rights, how to reply, what should be the professional indemnity, all this stuff. So if you attend all these courses, I think you will have some idea on how to react to the situation rather than get frightened with court and law. So we are 3 of us. I am Dr. Mahesh. I have a PG DMLE from National University. That is Dr. Anand Vinayaka from Narayan Nethralaya. He also has a PG DMLE from Bangalore National University. Then this is Dr. Ashok Nataraj from Trivandrum. He has got an LLB. So we will be speaking on some of the important topics that you might find useful in your regular practice. So I first request Dr. Anand Vinayakar to start his talk. There will be some overlap, or order will be little different, but ultimately it is all the same. Over to you, Dr. Anand.
Thank you, Dr. Mahesh and Dr. Ashok, for the opportunity. So first disclaimer is this is not legal advice. Yes, I did do a 1-year course, but a lot of it is experience, and I think I'm sharing it as an ophthalmologist more than a legal specialist. Medico-legal cases, unfortunately, have become a very big thing, and problem is we get a media trial before we get an actual trial. And I think once our reputation is at stake, then even if we are found not guilty later, the damage is already done. So in negligence, there are 2 ways the court looks at it, and the reason why I'm going to be talking about how compensation is calculated is that we should have a fair idea what is our liability if we lose a case and how we can work backwards in improving our medical indemnity or insurance. So that's the basic outline of this talk. So for example, if you enucleate the wrong eye in a retinoblastoma, or you come drunk and you operate, then the negligence is very complete, and there's no case. So such things in law are called res ipsa loquitur, which means the case speaks for itself. So here you're almost bound to lose the case. So this is not the focus of the talk. The focus of the talk is where we do our best as ophthalmologists in our best possible capability, and still somebody sues us, and then what are our chances of losing the case and how can we protect ourselves. So ophthalmology is not right on top. This is from India, Indian data. Surgery and gynae is still ahead, but unfortunately this is picking up, so we need to be aware. As far as law is concerned, there are 3 types of wrongs, and as you can make out, I'm only going to talk about the first one, which is negligence. Unethical practice and misconduct come under the NMC guidelines, which will not be part of my talk. So how negligence, we understand the English language word, but what does law define as negligence? That's important for us to know. So negligence is that the 3 Ds have to be present. The first one is you should have a duty of care. If the patient was never yours to begin with, then even if something went wrong in your premises, you can possibly get out of this negligence case. The second one is once you have this duty, then you should have something called dereliction of duty, which means you should have violated that duty that you are set to perform. And damage, again, damage in English language we understand. That is like, for me, damage would mean that I damaged the eye. But not for the law. For the law, a damage is something that he or she can claim a compensation for in monetary terms. So that's what they understand as damage. So when the 3 Ds are present and you are part of the 3 Ds, then only a negligence case can come against you. So when does duty start? Well, duty starts when you accept the patient. So a lot of questions were asked, okay, what if I give free service? What if I'm not charging the patient at all? I'm running an NGO, patient comes, then am I negligent? Yes, earlier you are not, but more recent judgments, I'm sure the other speakers will allude to it, that even if you provide free service, you can be sued for civil negligence. So when you accept the patient, when the patient comes to you and pays your consultation fee or can prove that you are the accepting doctor, that's when the duty starts. When does the duty end? I think this is important for us because sometimes if we have not completed the circle, we may still be part of that negligent circle. So firstly, if the patient is cured and then had another disease later on, perhaps you are not going to come in that ring. Or you refer to another physician saying, okay, I am a retina specialist, I'm not doing cataract, I'm sending to someone else, and the complication happened somewhere else. Even though you may be the primary person who sends there, you might not be part of the ring. Exceptions are there. In our case, fortunately not, but in the larger surgery, gynae kind of medicine thing, if a patient dies, then obviously the duty ends. Or if the patient decides not to continue with you. So these are the 4 conditions accepted in law. Now, what is dereliction? This is a little more difficult to explain and understand in definition, but the basic way we can understand it is what a common accepted practice is expected from us, not the best doctor. We don't have to be the world's best ophthalmologist. We are not going to be compared with the world's best ophthalmologist. We are also not expected to be the worst ophthalmologist. We are supposed to perform the standard accepted care. Now that accepted care, fortunately in ophthalmology, is very well set. So for example, if you are going to do a ECC or an open sky vitrectomy when today's field is a closed vitrectomy, and I'm just giving you examples. So if the field is, this is where majority of your people are doing and this is accepted SOP, and you are following that, a complication from what you have done does not put you at negligence. This is our greatest fear. I did some surgery, I had a complication, am I going to be negligent? No. If you can prove that you have followed the steps and the expected steps, then you are not. Now comes, what does the court look at? So how does anyone claim compensation against you? Now somebody has sued you, or so what are the 2 things the court will look at? Firstly, is this a criminal case or is this a civil case? Now criminal cases are beyond compensation. In criminal case, you are set to go to jail. There's a punitive action. You have to pay a fine to the government, to the court, and you have to serve a sentence. So this is not compensation. This we are not even going to talk about. That's criminal law. But in civil law, when the patient is hale and hearty, but there is some damage they claim has happened because of your surgical or non-surgical intervention, that is called a civil case, and that's where compensation comes in. Now, why do we need to calculate compensation? Why do courts have a problem? So firstly, unfortunately, we don't have an organ-specific liability. What does this mean? We don't have if you damage the liver, this is the highest compensation. If you damage a foot, this is the highest compensation. And eye, unfortunately, we don't have that in India. So that means a basic standard formula will follow whether you have killed a person or maimed a leg or done some complication in intraocular surgery, it's going to be the same. The next one is there's no limited liability, which means that they can sue you for 10 crores, they can sue you for 5 lakhs. There is no ceiling, unfortunately, in India, and a lot of it is based on the judge's discretion. Therefore, we need to look at formulae. The court uses one of 2 methods of deciding how they will assign the amount of value that you have to pay as compensation. The first one is a little more important one because there is a formula involved. The other one is more discretionary. So let's spend a little extra time on multiplier method. The classical case to understand this is Ashish Chavan versus Indian Air Force. A soldier sues the Indian Air Force saying that I got HIV because you gave me faulty infected blood. So that's the long and short of the case. So he sues the Indian Air Force for 95.3 crores. It is dismissed in the Consumer Forum, the National Consumer Forum. He appeals in the Supreme Court. Now, this case became important because formulas were set in. So 95 crores, how did this soldier say, I want 95 crores? So firstly, he said, okay, this is how much I traveled from my town to Delhi for treatment. This is how much I spent for medicines. This is the loss of salary I had based on my current salary and the extra salary that I would have got with promotions going forward. See, assuming that his life has come to now a standstill. Incidentally, he could not get a job again. He had a divorce. So a lot of that was also there. Then he says the lower 3 numbers, 10 crore, 40 crore, 40 crore, is where the discretionary part comes. I cannot quantify my mental agony. My mental agony may be 100 crores, yours may be 2 crores, anything. It's, muh mange rakam, as they say. So the top one is called pecuniary, which means where you can assign a financial value, and the lower one is non-pecuniary, which is sort of arbitrary. So now this is how he divided his salary claim, and as mentioned, this is how much he was earning, exact amount into 12 per year, this many years, up to retirement and so on. Now, what did the prosecution do? The prosecution is now the government. Imagine you are now suing the Indian Air Force. So they have set the additional Solicitor General represented the IAF, and they tried to prove that, first of all, these are the things they said, we don't even owe you a pie because of the following reasons. And so most of the times when they look, the respondents look at it, they look at for procedural changes, how you violated a certain procedure, that you did not, perhaps you didn't give your tests on time, your lab examinations on time, and so on. And so on and so forth. As you can see, the ASGs defended their case, but the court said no. The court said that you have to pay. And how did they calculate it? So from 95 crores, they came down to 1.15 crores. Now that's a huge difference, isn't it? So how they did it was, they subtracted the amount of money that he was getting as pension for the past 7 years that this court was the case was being fought. And then they said, okay, future income is so much. And now for all of those 10 crore, 40 crore, 40 crore, mental agony, other things that you saw, they said, no, we will fix it at 50 lakhs for all the other non-pecuniary mental agony calculation that you had. So from a 50 crores, they brought it down to 50 lakhs, still a large sum of money, but I'm just saying this is how the formula went. And additionally, they said that you have to pay this 1.5 crores, and the Supreme Court said you can divide, that half of it can go from the Indian Air Force and half of it from the Army, because the Army had actually run the hospital. In addition, they said that you will get lifetime treatment and your treatment costs will also be covered. So this was the judgment. Now this led to the heads of compensation. So the pecuniary damages are expenses relating to the treatment, hospitalization, medicine, and so on. The second one is the loss of earning and the future medical expenses. And the non-pecuniary was the damage of pain, loss of amenity, in his case it was divorce, and loss of expectation of life. Now, if you have a simple injury, the court is going to use 1, 2A, and 4 in the things that I just mentioned. And in serious injury, maybe like a loss of a limb or something, and in our case, a loss of an eye, they could also add 2B, 3, 5, and 6, which happened in his case, which is why he got a 1.5 crore. The next one is the next modality on how they calculate it is the just and reasonable, where it is little more arbitrary. So here, there's a lot of guesswork, and it depends on how well the lawyers fight. So there are some cases there where the multiplier method was not being followed. So here, the court decides what will it take for the patient to get back to his normal position before the injury, and that's called restitutio integrum. And unfortunately, this is a lot of arbitrary and based on the judge's discretion, so it can vary. A good way of calculating that is from ROP. Sorry, this case is very close to my heart, but this is where you can decide when the child, this infant who turned blind, who does not have an income, how will the courts look at it? So this case was a 1.8 crores. So this case shows us how is ROP, how is calculation done when there's no present income and the baby is not it. And so this is how they calculate it. So there's no income in the formula. There's instead the expenses of the treatment, hardship to the mother, and the future care until the child turns a life expectancy of 70, and that might change as our life expectancy increases. So that's how the 1.38 crores plus interest became 1.8 crores. Now the largest compensation in medical history in India is 6 crores. And how was that done? Because the lady who died was a Indian, of course, but was studying in the United States. She was an NRI, and she was earning in dollars. So the entire compensation of calculating the salary and what she could earn in the future was all multiplied from US dollars. So that's how it became 6 crores. And this is the exact charge sheet in the judgment that came on how they calculated it. The numbers are not important, but that's how it is. So the Supreme Court led these 11 points of negligence. I think these are important, where we say that, it is not an error of judgment. If there are two ways of treating this patient and you have chosen one over the other, you cannot be held negligent so long as there is at least a group of people who say that I would have also done that. So more larger principles of law, Dr. Ashok will cover, so I'm not going there. And we are still waiting for this, where the Home Ministry has said to decriminalize medical negligence deaths. So the legal principles that come from here is that we are only going to be judged based on our so-called specialty. So if you call yourself a specialist, what the duty and that is expected from you is much higher than if you call yourself a generalist or a comprehensive ophthalmologist, and we saw the formulas. And I'm going to end with a medical indemnity. So there are some principles on how much insurance we should take for ourselves. It obviously depends on what kind of care you are giving. For example, in ROP, the recommended amount to be taken is around 2 crores, because you saw the 1.8 crores, and at that at the current age, if a child goes blind and there is a negligence case against you, it could go up to 4 crores if the parents' earning capacity is more, as you saw from the NRI case. So roughly they say at least a minimum of 50 lakhs, and we have professional bodies, the IMA, where you can take it for a lower premium. They also recommend, lawyers recommend that you divide this into 2 agencies. So you don't take all your things from one, you can take 20 and 30, and of course the more you take, the better. So at the end of the day, how do we safeguard ourselves from medico-legal negligence? Firstly, exercise reasonable care and skill, which means what is taught to you and what everyone else is practicing, do that. Maintain great documentation. I know both the next speakers will dwell on it a little more. A lot of the negligence cases can be avoided if we just speak to the patient. If we are transparent about what happened, even if it's a complication, and they understand that you've tried your best and a complication is bound to happen in the best of hands, they are going to be part with you and they're not going to sue you. And I think at the end of the day, that's what we want. And of course, they say trust in God and everything else, go to medical indemnity. So yes, I think in today's world, if your institute is covering you, good. If not, it's still recommended that you take personal. Thank you so much.
Thank you, Dr. Anand. We can have a few questions and suggestions. See, all of us are having some experience in life where we went through some legal thing. So you can all share that. Unfortunately, we don't come out and share our problems with others, so that we don't learn from our own mistakes. Our fraternity. So you can have any questions. 2 things I was just thinking. One is that if the patient is a child, the compensation will be high. That is one thing. If you are doing a cataract surgery in 70 or 80-year-old, it may not be that much compensation. The second one is people don't go to civil case. Civil case because you cannot ask for big compensation, because you have to give a court fee of 10% of whatever you are asking. That means if you are asking 5 lakhs on one end of Thalmaides case, you should keep 50,000 in the court as court fee. So that is why people don't go to. But in consumer courts, even in district level, you can ask for 50 lakhs. That is the limit. And National Consumer Redressal Forum, it is 12 crores. 12 crores. Just you need a white paper and a pen. That is enough. That is why a lot of litigations, unnecessary litigations are coming. Any other comments?
Yeah, one thing is, the person or the complainant can ask for any amount of compensation. That is his right. So whenever he asks you some huge compensation, you should not be worried. Because, for civil damages like tort, the compensation is called unliquidated damages, because the damages are not decided early. So the person can claim, the court, as he said, they will decide, and whatever compensation the court feels right only will be given, because they will ask for a huge amount. So it doesn't. So whenever you get a notice asking for a huge amount, I think you should not get worried, because that's where the game starts only. It is not the end.
Any experience or comments from the floor? Anybody can? Usually what happens is, the patient can write a letter accusing you that you did, You have to give a letter reply to that patient. That is one. Second, you can get a letter from advocate representing the patient. That also you have to give a reply. Number 3, you can get a notice from the court. You have to submit all the data. So these are the 3 levels that you can. The first, when the patient is just sending one letter, you don't need to divulge too much of things that you don't give away initially itself. But the second and third, that is from advocate and from the court, you have to really defend your case with strong evidences. So that is.
So as Dr. Mahesh said, the process starts with something called as a legal notice. What will happen is, if a patient has got a grievance against you, he will send a legal notice through his advocate, saying that you have done me wrong, you give me this much compensation. Now you have to give a reply to that legal notice. When a legal notice is given, it's still not a case. It is just that the patient or the complainant is informing you that he has got a problem. Suppose you decide that I'll give the compensation, finish off, that's it. But again, at that time, you have to give a reply. And giving a reply is very important. So when the patient sends you a legal notice through his advocate, if you don't reply, not giving a reply will be held against you when the case goes to the court of law. And if you give a very good reply, that case will end at that point of time, because the patient or the complainant will feel that there is no point in going, or his advocate will say that, see, there is no point going ahead with the case. And once you, after this process of legal notice only, the person will go to the civil court or consumer court for the actual case. So these are two different things.
That time when you send a reply to the court, you have to keep the whole case records, whatever evidence. I will give one example. In 2006, I have treated one VKH syndrome. I'm a retina person, so one VKH patient came with hand movements and all this, both exudative RD. I gave him methylprednisolone and steroids. He became 6'6". But 3 months later, I got a letter from his advocate saying that after I gave steroids, his skin has turned white. All these vitiligo patches are come because of my medicine. So that time I knew that this is part of VKH. So I gave a strong reply, including angiography finding. This is a known case of VKH and this is part of the disease. He never went to the court. They understood. But just like that, if somebody is giving a notice, you need not divulge everything, all the details, because they may use it against you when they really go to the court. So that is one thing.
The thing is, it's the patient's or the complainant's right to complain against you. You should not feel bad. Just as you have the right to defend yourself, the patient has a right to complain against you. And there is law also, no? Whatever he writes, that's not the end point. Okay.
Yeah. So thank you, Dr. Anand. He has to attend another panel on his. So I request Dr. Ashok Nataraj, LLB, who is a retina surgeon, senior retina surgeon with more than 20 years of experience, is working in Trivandrum. So he will give some insights into the liabilities. And this is going to be a big talk, liabilities. You can interrupt and ask questions also. No problem. This is a closed group, informal sort of. So
it's not necessary that I complete my talk also.
Yeah. So we also learn from all of you. Because we are not experts. We just have one small degree or diploma, that's all. So over to you, Dr. Ashok.
So my talk is like on liabilities of medical practitioners and related laws. See, now the Indian Penal Code, which was made in the 1860s, has now been replaced with the Bharatiya Nyaya Samhita. So in the past few years, a lot of changes have come as far as medical legal law is concerned. So we will touch upon the whole process, how this works and the liabilities. Some points Dr. Anand has already covered. Now, who is afraid of the big bad flu? That should be your attitude when you get a medical legal case. Because, just like you deal with emergencies in medicine, you don't get worried when a patient is very sick. No? That the attitude should be the same when you get a medical legal case, because you are in the right. Now, this is what a lot of people have told about negligence. Like when a doctor does not treat a disease which is treatable, it is negligence. So the basic thing is something called as standard of care. That is the key word. It's called as standard of care. So medical practice or negligence occurs when a health provider strays from the recognized standard of care in the treatment of the patient. Okay. So what is standard of care? As Dr. Anand Danekar said, standard of care doesn't mean the best treatment. It just means reasonable treatment that is followed by majority of the doctors in your community and it is recognized. So that is standard of care. And an important thing is standard of care is not only actionable. Not doing something also is a negligence. So suppose our patient has got appendicitis and you just give some paracetamol and keep on waiting, the appendicitis becomes an abscess and it bursts and the patient, There has been cases where they say that the patient refused surgery and the doctor has been, prolonging surgery like that, and patient had some adverse event. So not doing something, not following standard of care, by not doing something is also negligence, as important as doing something wrong. Now, these are the components of negligence. First thing is, the patient comes to you and you start treating the patient. At that moment, a contract starts between you and the patient. Okay, so that is the duty of care. The patient comes to you, you are giving back treatment. So that is the duty of care. So there should be some relationship between you and the patient for negligence to happen. That's the first step. Second thing is, now you're treating the patient. Now you're not treating them properly. There is a breach in the duty of care. And because of that breach in the duty of care, there is some injury happening to the patient. See, suppose, when you're doing an intravitreal injection, there is a small corneal erosion, or your needle has touched the cornea, or there is an epithelial defect. You have created an injury. But after some time, the corneal epithelial defect is healed. It has not caused damage to the patient. Vision is still 6/6. So that is not negligence. And because of that injury, there should be damage to the patient also. So all these 4 components should be there. Even if you are negligent, if there is no damage, there is no negligence. So these are the 4 components that should be there. I mean, you give a wrong medical prescription, like patient's vision is not lost, psychological trauma, I agree. Actually, there is no damage. So that may not fall under this category of negligence. Now, what are the liabilities? See, like a lot of things are breached when something happens, goes wrong between the doctor and the patient. One is the tort. Tort means it is a legal term called tortuous. Tortuous means twisted. So it is something called as a civil damage. Okay, civil damage. Civil damage means for any wrong, for such damage, the remedy is give money as compensation. And the second thing is Indian Penal Code. That is a criminal liability that the doctor has towards a patient. And the third one is the Indian Contract Act. See, I told you, I say, okay, I'll do cataract surgery, give you 6/6 vision. Patient comes, gives you money. Now, if you're not able to do that, there is a breach of contract. So the difference between this breach of contract and the tort is, in the tort, the amount of damages is not specified. It is called as unliquidated damages. The patient can claim any amount of damage, the court will decide what damage has to be given. But in the contract, like you have said, you give me 25,000, I will do FACO, give you 6/6. There is a contract. If there is a breach of contract, the liability is only the amount of money that you have asked for in the contract. Okay, you don't get 6/6 vision, you take this 25,000, end of matter. Okay. And then comes the Consumer Protection Act. That is also a part of civil damages under tort. Now, negligence as a tort, the most important part is unliquidated damages. It is a civil damage. The most important part is unliquidated damages. Damages that the patient can claim is not decided before. It is, patient can ask for any damage. The court will finally decide what damages has to be given. Okay. Then negligence as a crime. So, see, it depends on the amount of negligence. So, the most important part is there should be gross negligence as far as medical practice is concerned to call for criminal negligence. It should not be some small negligence. And how do you determine this gross negligence? First one, it is on the patient to prove that the doctor was grossly negligent. And second thing, depending on the circumstances, depending on expert witness, depending on a panel which is constituted to determine whether there is criminal negligence or not, it will be decided whether it was gross negligence or not. So that is the basic thing. And for a criminal act, there should be 2 things. One is guilty mind, mens rea, and actus reus. Mens rea means a guilty mind, a mind which is going to commit a crime. And actus reus means the action of crime. So these 2 factors has to be there in criminal negligence. But as far as medical legal negligence is concerned, we don't have any intention to harm the patient, correct? So we have a section called 304A, which says death or injury due to rash and negligent act by the doctor. So that is what comes. It is not intentional, it is unintentional, and it is not amounting to culpable homicide. So that is the section that is applied to doctors as far as criminal negligence is concerned. Then Consumer Protection Act, it is same as tort or civil damages. Only thing is, in civil damages, you can go to a court, civil court. In case of Consumer Protection Act, you go to a consumer court for the same thing. I'll just explain it later, whatever it is. And then as Dr. Anand Dinekar said, something called as a res ipsa liquitor. It means that you leave a scissors inside the patient and the truth speaks for itself. I mean, you don't have a choice. And in that particular point, it is the duty of the doctor to prove his innocence. See, whenever there is a normal complaint, the patient or the complainant has to prove that the doctor is guilty. But when you do something like this, the onus of proving guilty or not guilty will fall on the doctor. He has to say that, I forgot, or, it was there from before, or something he has to say. Now, this is the civil liability. And another importance of civil liability is, see, not only the person who is involved in that is held liable, the owner of the hospital or the HOD of that particular department, including the hospital director, will be held liable. This is called as vicarious liability. Now, why we talk about vicarious liability is, when you ask for huge compensation, it is not possible to get the huge compensation from a poor doctor. So they have to involve the hospital, the director, the HOD, to increase the scope of these things. They'll involve everybody and then only they'll file a case. So suppose you work in a hospital, the case will not only come against you, it'll come against the chairman of the hospital, the director of the hospital, and plus you. And you will only be the third person in that whole list. So that is how this works. That's called as vicarious liability. Then another thing as far as criminal liability is concerned is, I told you, rash and negligent act causing death of the patient. And the most important thing is criminal liability is the Dr. Suresh Gupta's case. Supreme Court in 2004 said that only when negligence was so gross and his act was reckless to endanger the life of a patient, criminal law for offence under 304A of the Indian Penal Code will apply. So this gross negligence has to be proved for criminal negligence as far as that is the only saving grace we have as far as criminal negligence is concerned. Then error of judgment is not negligence. See, you have a case, a patient comes with exudative RD. It could be VKH, it could be CSR, it could be a lot of other things. So it's a whole spectrum of differential diagnosis. So I treat an inflammatory kind of situation, which could be an atypical CSR with steroids. You cannot be held liable because it is error of judgment. I mean, that is not negligence because it's a panorama of situations which can mimic. And each doctor, according to the situation, may have different role of treatment. Now, why this happens, again, Dr. Anand Nekar has said communication gap. The most important cause of medical negligence cases is from the doctor community itself. And that is because of a stray comment by a junior doctor, usually. See, what happens is, many a time, from the lower level hospitals, they go to a bigger center for second opinion, third opinion. There, the patients will be seen by fellows. Okay? And they'll see the patient as a very small stray comment from them and say, who has done that? What happened? The whole thing is now gone. Those stray comments is enough for the patient to feel that, his life has been ruined by the poor doctor who has referred this patient to the senior person. So one thing I would like to say is, if at all you are referring to any senior doctor, you identify the exact person to whom you are referring and send it directly to him and say that this patient is going to come and see you. Don't just put him in the big pool. And that's where all these problems will come. So doctor community itself is responsible for, giving the wrong impression to the patient, and that backfires on us also. Now, a patient has a grievance against you. So where does he usually file a case? Usually he will file a case in the Consumer Protection Forum. So Consumer Protection Forum is a quasi-judicial organization. It has got 3 tiers, one in the district level, then in the state level, and in the national level. And after that, the case will go to the Supreme Court. So that is the whole thing. So if your claim is up to 50 lakhs, it will be, the case will be filed in the district forum. From 50 lakhs to 2 crores, it will be filed in the state forum. About 2 crores, National Commission will be filed. Now, where will the case be filed? It depends on the convenience of the complainant. So suppose you treat a patient from Assam. He comes to Delhi. He goes back to Assam and he files a case. He can file a case in the Assam Consumer Protection Code. And every hearing you have to go to Assam. Okay, it is a wish of the complainant. His place or place where the cause of action has happened. That is, the injury has happened. So that is one bad thing about the Consumer Protection Code. Then electronic hearing, video conferencing is there. Alternate dispute redressal is also possible. The most important theoretical thing about Consumer Protection Forum is civil courts are already burdened with a lot of cases. And civil courts, the case drags for a long, long time. And the civil court, I said, 10% of the damages you are claiming you have to already give. Then only you can file a case. And in Consumer Protection courts, it is said that the disputes had to be resolved within 3 to 6 months, at least in theory. But in practical, it goes for years and years and years together. That's a different thing. But in theory, it is supposed to be over in 3 to 6 months. And for Consumer Protection Court, it is a very loose thing. The complaint can be given in a very plain sheet of paper. The patient himself can be his lawyer. It's a very, very, loose thing. And the people who are sitting there in the panel, one person will be in the rank of a district judge or a high court judge or a Supreme Court judge. Other 2 people will be ordinary people who are having high position in the society. So it is a very, very difficult task to convince these people about medical issues and medical negligence. So I cannot say, see, that patient had disc leak, so it is not CSR. I know it. I mean, they will not understand a thing, So you have to, convey your message in such simple terms that even they can understand. So it's a very difficult thing as far as a doctor is concerned. Now, why Consumer Protection Forum is this thing means up to 5 lakhs, no, you don't have to pay any fee to file a case in the Consumer Protection Forum. From 5 to 10 lakh claim, you have to pay only 200 rupees. And about 10 crore, it is 7,500 rupees. That is why people are claiming for 100 crores, 300 crores, because whatever you are claiming, the amount of fee that you have to put in the court is only 7,500. Just see if they go to the district court, for 1,000 crores, they have to pay 10 crores, no, to the as court fee. So any Tom, Dick and Harry, if they want to screw your life, no, they can go and give a case in the consumer court. You have to run behind it, no? So that, I mean, it has been done as a favor to the consumer, because consumer is the king in a consumer protection court, but that usually is misused by many of the people. Another important thing is there is something called as a limitation period. Suppose, a damage has happened. So if more than 2 or 3 years have passed after the period of cause of action or the damage has been done, then there is something called as a limitation period after which the person complainant cannot give a case in the court of law. But practically, it doesn't apply, because the complainant will say, I was at Gulf, or I was somewhere, I was sick, I was incapacitated, so give me an extension. So up to 10, 12 years also, extension is given. That is the discretion of the court. And another important thing as far as ROP is concerned, suppose you treat a patient with ROP, the child loses its vision. Now, the limitation period starts from the time of majority. Like from 18 years plus 2 years is the limitation period. So till the child or the person becomes 22 or 23 years, the person has the right to give a case against you. You understand? So the game is not over. So whenever you're treating ROP, you have to be very careful. You have to maintain that good rapport with the patient all the time.
And keep the records.
Keep the records safe.
OP cases, I think 3 years minimum, and IP surgical case, that is your coming.
The important point there is just try to keep all this plus minus records forever, because that is the only evidence you have to defend yourself. You cannot say that the limitation period is like that, so I didn't keep. That's not an excuse. I mean, if you want to save yourself, you better be smart. That's what. So this is why I'm talking about, and the procedure of how this happens is, first thing, the patient will file he'll give a notice, legal notice to you. Then you have to reply to the legal notice. The complainant is not satisfied, he will give a case in the Consumer Protection Forum, and that will be given in the lowest forum, that is the district forum. There you have to fight your case. If you fail the case, the appeal will go to the state forum. If you fail there, it will go to the national forum. If you fail there, the final appeal is the Supreme Court. And the process is, once the case is given, you will get a summons saying that a person has given a complaint against you, give me a reply. Okay. And that reply should be given within a period of 30 days. Okay, it is very, very important. 30 days is very important. Suppose, you don't give a reply within this period of 30 days, then you don't have a right to reply. Okay, the court will decide the case based on whatever the complainant is saying. So, see, if you go to a lawyer, lawyers are like very professionals. They have got 100 cases like what you have. You should not feel that yours is the only case that is there with the lawyer. So, and medico-legal things and medical things, the lawyer absolutely has no idea. Whatever you say, he will tell based on that. So, whenever you get a summons, from day one, you have to be fully involved in the case. You should go behind the lawyer and make sure that written statement or reply is filed on time. Because if you don't file the written reply on time, you lose the right to defend yourself. And then whatever the patient says only the court will believe. Okay, so that is very, 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 very important, because as a medical professional, you have to run behind the patient and treat him. In the legal profession, the lawyer will chuma sit. You have to run behind the lawyer and get your things sorted out. So that is very, very important. And the time for appeal is within 30 days. And in the new Consumer Protection Act 2019, whenever you have to give an appeal, you have to pay 50,000 or 50% of the amount decreed by the previous court. So suppose a previous court has awarded us compensation against you, 50% of that you have to file in the consumer court to go for an appeal. So all these things, you have to make sure. And these are the precautions you have to take. I mean, keep the record safe, 2 years for OP and 3 years for IP. That is it. But I'm telling you, if at all you have a doubt, keep the records forever because EMR stays. So, you have better to keep records forever and consent forms, be truthful and frank. And consent forms are very important and don't hesitate to investigate the patient. Suppose, headache, oh, no, I will not do CT scan, I will not do, don't be like that because now days are not okay. So whatever investigations, whatever little doubt you have, you express it to the patient and go for full investigations. And now I'll come to there is some confusion regarding the laws as far as consumer protection is concerned. Now the latest law is the Consumer Protection Act of 2019. Now, when the Consumer Protection Act of 2019 was first introduced in the Parliament, healthcare and healthcare professionals were included in the law. Okay. And then there was a debate in the Parliament, and it was amended where the healthcare and healthcare professionals or professionals, that word was deliberately removed from the Consumer Protection Act of 2019. So whenever there is a law, the court has to interpret it when the case comes to the court. The most important interpretation is called literal interpretation. Literal interpretation means the legislature who has made that law, what is the intention of that particular law? That the court will interpret and give a judgment. So it is clearly mentioned that, professionals, these things should be removed from the CPA it is not even mentioned. What it was there was removed. So in such a situation, what happens is, there is a confusion whether the CPA 2019 includes medical professionals or not. So for that, we have to depend on the interpretation of the courts in various case laws. Suppose a case goes to a court, how the Supreme Court interprets this law. Based on that, you have to decide whether this healthcare and healthcare professionals are actually involved in this particular 2019 Act or not. So for that, can you off that? Some sound is coming? That side, okay. So for that, we have two relevant case laws that have come up. One is in 2024, that is Bar of Indian Lawyers versus D.K. Gandhi, and the other one is Nivedita Singh versus Asha Bharati and others. Now, the D.K. Gandhi case, what happened was there was this particular person who went to a lawyer, and he said, I have given a check to a particular, somebody gave me a check and it bounced. Now, I want the money from that particular person. So, it came to the court of law, and the court decided against the person who was accused. And that person gave that money to this particular lawyer. Now, the person who had initially who went for a case with this lawyer had not paid any fee to this lawyer. So what the lawyer did, whatever money he got from the person, said that this is my fees, I will keep it, now you can all go home, like that. Then what happened, this guy went to the Consumer Protection Forum. He said, see, I am the consumer, I have given money, he is fighting a case for me. Now, according to the Consumer Protection Forum, I need a compensation from him. So that is this particular case, D.K. Gandhi case. Now, the Supreme Court reached the following conclusion. Supreme Court in CPA 2019 never intended to include professions or service rendered by professionals. Okay? So that is what the Supreme Court has clearly said. And second thing, what they said was, see, the basis of medical profession coming into the CPA Act is the IMA versus VP Shanta case, judgment. That is the basis. So the Supreme Court has now said that because the legislative intention was not to include professionals or medical professionals in the CPA Act of 2019, that includes lawyers and doctors, this particular IMA versus VP Shanta case judgment has to be revisited. That is what the Supreme Court has said. So the position is, it is not that Supreme Court has conclusively said that CPA Act of 2019 will not include doctors, but the direction in which it is going is favorable to doctors. So in such a scenario, I think it is up to organizations like IMA or AIOS to take up this matter. File a petition in the Supreme Court. So this was a 3-bench judgment. Now they have referred this to a 5-bench judge to revisit the IMA versus VP Shanta case, and suppose bodies like AIOS or IMA takes up this case, and if we can win it, probably our profession will be out of this CPA Act of 2019. So that is very, very important thing that has come up. Now the next is the Nivedita Singh case. Now the most important thing is you work in free hospitals. You give free treatment to the patient. Now if negligence happens, is the patient, can he go to a consumer protection forum and give a case against the doctor? Because, see, for a person to be consumer, there is a two-way traffic. You give service, he gives money for your service. So the Nivedita Singh case, what he said was, if there is no nexus between the amount paid by the patient and the salary that the doctor is getting, then this case will not come under the Consumer Protection Act. See, 1 rupee 50 paise you are giving in the OP, and the doctor is getting a salary. Now with this 50 paise, the doctor is not being given the salary. He is getting it from some other fund. So you cannot say that just because I gave 1 rupee, now there is a nexus between me and you, and it will come under the CPA Act. So that is also an important thing. So probably in free hospitals, if the organization is able to prove that the income from the free hospital has no nexus with the salary paid to the particular doctor, then that particular thing will not come under the Consumer Protection Act of 2019. So that is an important thing. Now the next one is criminal negligence. There is something called as 304A. That is death resulting due to rash and negligent act. So that is the criminal negligence for which doctors are usually liable. Now the Indian Penal Code has been scrapped. In 2023, it has been replaced by the Bharatiya Nyaya Samhita. So section 106 of the Bharatiya Nyaya Samhita corresponds to Indian Penal Code 304A section, which accounts for criminal negligence as far as medical profession is concerned. Now, what is the importance? See, initially, the legislature said that now doctors will be exempt from criminal negligence. That is how the whole thing started in Bharatiya Nyaya Samhita. Finally, what has happened is they have criminalized doctors even more than it was in IPC. That is the present situation of doctors as far as criminal negligence is concerned. So what does BNS 106 section says? Any person causing death of the other by rash or negligent act without intent to harm shall face imprisonment up to 5 years and or a fine. That is okay. Initially it was 2 years in Indian Penal Code. Now this has become 5 years. Now in the Indian Penal Code, doctor, registered medical practitioner, all those specific terms were never used. Okay. Now what did Bharatiya Nyaya Samhita said? They specifically used the term registered medical practitioner. That means a practitioner who has the right to practice in India. So they say if the act is committed by a registered medical practitioner during medical procedure, the punishment shall be imprisonment up to 2 years and or fine. So that means they have specifically mentioned registered medical practitioner during a procedure, something happens. Now he is liable for criminal negligence and up to 2 years. Imprisonment is mandatory. Okay? And or fine. Fine, maybe you'll get, you might not get. So when we talk about this to our lawyers and the people in the legal profession, they say that many a time what they will do is, they will say you stand from morning to evening in the court. That is also equivalent to imprisonment. And the evening you can go home. We can do things like that if the negligence is very small. Only in very, very grievous cases, usually this draconian measures are used. I mean, that is how they try to pacify us. Because there is a process where you are asked to stand from morning to evening in the court. Like it is equivalent to 1 day imprisonment or whatever, token imprisonment. Okay? So what Bharatiya Nyaya Samhita has done is, it criminalizes all acts done by a medical practitioner while performing a medical procedure. Specifically, it has been mentioned. So what started off as saying that doctors are going to be exempt from criminal negligence, actually when the law came, now doctors are in more soup. They are in deeper trouble. Now they are liable specifically for criminal negligence. Now how can you object this? See, there are a lot of provisions in the Bharatiya Nyaya Samhita which will exempt a person from criminal negligence. That is good faith doctrine. That we are treating a patient in good faith. No. Unfortunately, something happens. Then all these things, because this is specifically mentioned, all these things, all these, saving grace that is there in the Bharatiya Nyaya Samhita may not apply to doctors. Then, this is what I said early, and provisionals in Bharatiya Nyaya Samhita that can protect doctors is good faith exemptions, informed consent, standard of care, expert testimony. So, you have to be very, very, very careful. Ophthalmology, I think it's grievous hurt, not death due to rash and negligent act. But still, an informed consent, communication with the patient. All these things are very, very important now because it is better to avoid situations rather than go into it and try to come out of it because laws are not in favor of our profession. Then points to ponder like consistency of legislation. The legislature says we will not criminalize, and when the law comes, it is criminalized. Then discriminatory impact, then legislative intent and trust is lost, legal challenges, and the most important thing is impact on medical practice. Now we will start to practice defensive medicine. We will add more and more investigations. Even if it's a simple case, we will say you will lose your life, there will be blood loss, you will get MI, you will die. And majority of the patients who would have escaped by treatment will say, I don't want, because all these complications are there, I will not get treatment. So who is going to benefit from all this? God alone knows. Thank you very much.
Thank you, Dr. Ashok, for that very informative talk. So we have to wait for that 5-bench judgment from Supreme Court.
I think it has to be taken up by our body.
Yeah, that's
we
what.
have to really take
I think
this
there was
center.
another session yesterday on criminal liability. Yeah.
I'm talking something else.
Yeah.
We should be aware that there are extortionist group
Yes.
of lawyers
Yes.
who have friends with the sons and daughters of the judges and all, and they are into this kind of thing, extracting money
Yes,
by
yes.
raising a case, and they want out-of-court settlement like
Yes, sir. Yes, sir.
I am trapped in such a case. In 1998, PCT with 6x6 vision, the judgment in State Commission Delhi came for loss of sight, 1.5 crore rupees compensation. Can you imagine?
Yeah.
And I am fighting this case in NCDRC. In March, I contested myself because the other person can influence all my lawyers. I have to change 9 times lawyers. And the
Correct.
judgment is pending. So you have to understand the gravity. This is extortionist group.
Correct.
Yes, absolutely.
And I
Yes,
talked
sir.
there in the NCDRC, and all the entire court was for 2 minutes silent. I'm just talking.
Correct.
Being the president, past president DOS, this thing can happen. And
Yes,
I
sir.
talked to IMA, where I was the vice president DMA, Delhi Medical Association. Nobody speaks. Nobody wants to come in court matters. This is the tragedy. And how
Correct,
the
sir.
youngsters are going to face it.
Correct.
Absolutely, sir.
You're right.
Absolutely. Thank you very much for your insights. I think we should all come up with our experiences and we should contribute to so that from your experience we will also learn like that. So I'll.
Now I invite Dr. Mahesh Gopalashnan. He is the senior most retinal surgeon in Kerala, HOD retina surgery in Giridhar Eye Institute. He is also a multifaceted personality, a great academician. He has taken his diploma degree in law. Mahesh sir, I invite you for your talk.
Thank you, Ashok. Now we will examine few classic judgments that all of us should know. When we, in the other halls, we are all talking about evidence-based medicine. Everyone will tell that as per this article, we are doing this standard of care, some injections or whatever. So like that, in law also, there is something called classic judgments. So it is called judge-made law. Who makes the law? Legislature makes the law. Yesterday there was some big law being amended in Parliament, Rajya Sabha and Lok Sabha. So they make the law, and the court or judiciary interprets the law, and executives are there to implement the law. So this is the situation in India. So it is made by legislature, and the CPA 2019, as he has already told, there are some loopholes, and it is being fought in the Supreme Court. So the other laws are called judge-made law. It's case studies, or it's called stare decisis. So a Supreme Court makes one judgment. It is all other lower courts have to. It is binding to all courts in the territory of India. So you can quote that as per this judgment. This is the verdict. So you should know some of the things that has been told by Supreme Court. So you can do what is called a literature search. There is something called India Kanun, just like PubMed. You get everything. All the details of the judgment, it is available in the net. So you can limit the search like PubMed search, High Court and Supreme Court verdicts, just like PubMed search. And we can quote this in our defense when we quote something. So I will go through a few examples. One, this is not Indian law, what is called Bolam test. In Wolam versus Fry and Barnett Hospital Management Committee, this is still the gold standard of what the court examines. In fact, this was a case where the patient had some spinal surgery and had a paralysis or something, and they called other doctors and they said this is a standard of procedure. So the doctor escaped from litigation. So this is what is called Wolam test. So as Dr. Anand has already told, there is a standard of care, and if you have not adopted the standard of care, and then that is you are liable. So, for example, I will give one example. Standard of care. You got an endophthalmitis. What is standard of care? AC tap or vitreous tap immediately, then intravitreous injection. As per the guidelines, immediate vitrectomy. You give topical, systemic, intravitreal antibiotics. As per any book, AIOS guidelines are available. You do that, and then you are not that you have done everything. Standard of care. You don't have to worry. I will come to some of the endophthalmitis verdicts also. Now, number 2 is criminal proceedings. This I am not going into details. Already Dr. Ashok and Dr. Anand has covered. This is a classic case of Jacob Matthew versus State of Punjab. The court has already explained that unnecessarily doctors should not be harassed by charging criminal negligence. This also is now after BNS has come, there is some problem. The real life scenario is a little different. Even though court says the BNS 106, in a real life scenario, like where you have a death or a cluster endophthalmitis, there will be police, there will be politicians, there will be media. They will all make a soup out of your life. I mean, they are all there to harass you. So these 3 dangerous things, police, politicians and media, will make our life miserable. That is why many of you might have heard the cases in Trichy, and which has caused considerable pain to healthcare providers. A person who has served the community for 30, 40 years with community service, he was suffering, and he had to go to jail also. So that is what. Then BNS 304 and 304A, already Dr. Ashok has covered. Then number 3, what is ideal consent? All of us give blanket consent. You, before surgery, you just, one printed thing you just sign. It has no value actually. So what court has told what should be there in the ideal consent. It is a classic Samira Kohli versus Prabha Manchanda case. All of you should know what is this case. Actually, Samira Kohli had an abdominal biopsy or surgery for diagnosis of, then the doctor found that there is an ovarian tumor, and he removed the ovary just by telling the patient's mother. Actually, the patient was an adult, 40-year-old or something. Then later, it went to the Supreme Court, and Supreme Court said, unless there is a dire emergency to save the life, you cannot do anything outside the consent. So that is what. For example, one situation I will tell. Suppose you are doing a EUA, under examination under anesthesia to the eye, and you find that there is a retinoblastoma or something, and you enucleate the eye without the consent, you will be in trouble. You can be in trouble. So that is important. This is one situation that is pertaining to ophthalmology. That's why I am just telling that. So consent should be there. Otherwise, give one more GA. That's it. You don't have to worry about that. So always, there is another area in this. Suppose you take a consent for cataract surgery, and there is some deviation, like a nucleus drop. A nucleus drop comes. So you are calling one VR surgeon, and he is doing. So is it possible? You have not taken consent for nucleus drop or for vitrectomy. So usually in our consents, there will be one or two lines where they say that if there is a variation in the course of the surgery, you can you can take deviation as for the benefit of the patient. That one or two lines will be there in all cases. Otherwise, in gross cases like enucleation and all, you cannot do anything outside the consent. So these are all some practical points that we come across in cataract surgery and other cases. So legally valid consent should be there. All of you know it should be given by the person, informed written consent. Printed consent has no value actually. That's why when we have a big printed consent, at least you should make them write in their own language. I have read this and understood and give full. One line at least, because the whole thing patient cannot write. In retina cases and all, we give a small consent written by the patient's bystander itself. But unfortunately, it's not possible for a cataract surgery with so many complications. At least make sure it is in the local language Hindi or whatever, and the patient and bystander should write, read the whole thing, and then that one line you can make them write. Otherwise, blanket consent has no value. Repeated judgments are there by different courts, including Delhi. So, and doctor should sign the consent. I did a survey, 25% of doctors even have not habit of signing the consent at all. So that is the situation in many places. So that is, and most of the medical litigations are due to improper consents. Some studies are there, even from Korea, and they say that it is due to improper consent. Now, ROP special scenario, already Anand Vinekar has beautifully elaborated. The compensation was 1.38 crores. This, you should understand that this happened in 1996, when there was no ROP guidelines available in India. And at that time, this was fought. Unfortunately, the whole case was screwed up, and the pediatrician, the superintendent of police, and government of Tamil Nadu had to pay this much amount. I don't know what was the exact reason, but they should have lost this case if that was the standard. At that time, there was no standard of care like that. So the take-home message is, the smaller the patient, you have better, higher coverage you have to expect, as Dr. Anand has already told. There is Maharaja Agrasen Hospital versus Master Rishabh Sharma, recent one, and 76 lakhs was given. These are all cases where they have missed ROP screening protocol, completely missed ROP screening protocol, and they have not documented. In one cases, it was done, but it was not documented. Something not documented is as good as not done. That is important. So make sure you document everything. Tell if the patient doesn't, the parents don't bring the child, that is their headache, but it should be written and documented. So the Maharaja Agrasen case was there, and so be aware of the latest guidelines, especially ROP, and never miss the screening in time. And government doctors are not immune to CPA, Consumer Protection Act. As he was telling, they all pay 10 rupees for the OP ticket. And you have to prove that 10 rupees is not given to this doctor, but that is not possible. So all government doctors are liable to Consumer Protection Act. So that is, and the other thing that already explained is, ROP babies can see you after 18 years. With the current EMR, you will keep the records lifelong. So there is no problem. You have a server, backup, everything like that. The old paper EMR will get damaged after a few years. That's the problem. So younger the patient, more the compensation. How compensation is calculated already. Now, liabilities in camp surgeries. Are we liable if you do free surgeries in a camp? There are cases, multiple cases, they say that this is against, this was in State Consumer Redressal Forum, they say that camp cases does not mean compensation can be reduced. If the complete treatment of everyone is free, then it can be, you charge one patient this much, other patient free, or they are not free service. That is not free service. So court clearly says that in such cases, camp cases are also liable for litigation. Yeah.
One thing is, this will not come under the Consumer Protection Act only. They can go to the civil court or other criminal courts and give a case also. This liability that Dr. Mahesh is talking about only is for the Consumer Protection Forum, because they are not charging the fee. That you have to clarify.
Even that, there are, this was also in consumer disposal, consumer case court only. There also they said only the few patients are not charged, others are charged. It is not, but there is another verdict somewhere in Maharashtra, somewhere, they do complete free treatment, where the court has said there is no consumer relationship. They even food, everything is free for everyone. Yes, there is one place, I could not get that. I have read that verdict. So camp cases are also, you are liable. Bad outcome complications are not doctor's fault if managed properly. This is extremely important. This classic verdict in 2005. After sterilization, somebody got pregnant. And court said that none of the procedures are 100% safe and secure. You can get complications or some, if the treatment is not going as per the patient's decision, you can have complications. So this is important in our scenario, like endophthalmitis. Okay, there are plenty of cases in NCRD, National Consumer Redressal Forum, like scleral melt with endophthalmitis. They say that it is a known complication and the doctor has given reasonable care or standard of care, he is not liable. This is another case, government of NCT versus Maharaj Kishan. The underwent cataract surgery in Delhi, and there was a medical board, and they found that all the steps were taken, so it was dismissed, saying that the standard of care was done, and this is a known complication. And in the informed consent, it is written. Rarely one person can have this problem. So this is one. Then the another verdict, it is unrealistic demand for compensation should not be allowed. This was interesting case. I think 2 years or 3 years back, somebody asked for 6 crores. There was an endophthalmitis after ICL, and the patient had, and he wanted 6 crores on various grounds, including treatment, loss of earnings, future medical expenses, damages for pain, suffering, and loss of marriage prospect also. Court got very angry and they said this sort of, there is increasing tendency among complainants to overvalue their claims in consumer complaints. And they want to curb this because already the court is overburdened. They told the person to go and give a case in the civil court. So this is another important thing. Unnecessarily, huge amount is being asked for small things. So compensation limitations already Ashok has told. Now there is another one called the difference of opinion among doctors is not negligence. Suppose there is a exudative RD. I say it is CSR, he say it is VKH or something. And we have two opinions. It doesn't mean that there is a negligence. Both of us have recorded the whole findings. And court has said difference of opinion, especially in the management. Some of the disease management, DME, for example, injections in diabetic macular edema. I say there is no point in giving. Somebody else will say there is. So these sort of variations are there, which are not negligence. Difference of opinion. So this is what I said. And when to do cataract surgery. Some people operate 6/6 vision with glare also. So, there are cases where medical board has told there was no need of cataract surgery some years back because the vision was 6/6. So this sort of difference of opinion, that also is not negligence. Endophthalmitis, I am coming back to endophthalmitis because that is the most dreaded complication that all of us face in our life. You should know that 98% of judgments in Supreme Court or highest courts are in favor of doctors, not for the patient. Okay, plenty of cases, Shyamlal Nadia versus O.P. Nayak, it's a non-complicated, the court repeatedly says that this is a non-complication and you have taken all standard procedure, and that is why there is no negligence. Plenty of cases are there, Ina Jain versus Parvadevi, a lot of cases. There are some cases where it has gone against the doctor for small things. Like this case from Kerala, it was, a doctor was found liable just because there was a delay of referral of 3 days. The doctor was just keep putting drops and there was a delay for 3 days and later it became very bad. So these sort of things. There was another case where the diabetes was not controlled before surgery or not even checked before surgery. So the court found that doctor is negligent. So small steps are there where if there is a lacuna and this has gone against the doctor. Another one, actual vision of the patient was not even mentioned in the case sheet and findings were not recorded, and then endophthalmitis happened. This also went against the doctor. So unless you are negligent like delay or not recording or not documenting, there won't be any problem if you do the standard of care when there is an endophthalmitis. That is what I. Then coming to one of the last thing, off-label medications. This actually is not very valid now. 3-4 years back or 6-7 years back, this was very important, especially when we use the Avastins. There are a lot of drugs that are used off-label, including triamcinolone, TPA, various antibiotic and intravitreal injections, everything. There are cases for and against this off-label medications, like for example, post-Avastin endophthalmitis. This case said that doctors has done all possible, taken all consent and everything was okay. So they found that there was no negligence. In another case against, in Telangana Consumer Redressal Forum, they said that off-label means off-label, it should not be used. So that is, there is no argument in favor of using that off-label. So compensation was awarded for the patient. Now there are guidelines, VRSA, AIOS guidelines for Avastin use and all. But this came 6-7 years back when there were no biosimilars. So at that time, we were forced to use Avastin as off-label. Now there are plenty of biosimilars. Now it will be little difficult for us to defend any endophthalmitis if we give Avastin and get an endophthalmitis. So this is the current status now. Now, so these are some of the guidelines, even 10-11 guidelines, judgments that we should all know. We can quote this in your reply to the court. So that is why I thought this is important. You can have some question answers and interaction so that we also learn from all of you. Thank you very much.
Can I speak?
Yes, sir.
Yes, sir.
There is a decision in Supreme Court in October 2024, and the emphasis is, it's an I case, PGI Chandigarh, where there was a ptosis, and after the surgery, the ptosis increased, and the patient vision also got deteriorated. But court said that the expert opinion, now they emphasize Bolam's test and the expert opinion. If the expert opinion says that this is no negligence, because there can be worsening of vision for whatever reason, there can be increase of ptosis because of whatever reason. If the expert opinion of any doctor, which has been referred or the committee suggested, they have not defined that there is a negligence, then it is not a case of negligence, and they turned down decision of NCDRC, which gave them a huge compensation.
Correct.
So it was, the doctor was free. So we have to understand the law that the expert opinion is very important, and the expert opinion depends only on your documentation. Because we are, as an ophthalmologist, we are doing what is needed. But if you don't document, and if you don't have the history that well, you have done these things, 3 days delay, you could have always mention one thing, that we have advised the patient, but the patient wants that he would still like to be continued with this treatment. That's why we something that every day you are having a thing that the patient cannot afford further expenses, whatever. So the documentation, everything is so important, and so many extortionists and people down in the lawyers, particularly in Delhi, we are finding that consumer lawyers for medical negligence, they are flourishing. There are so many cases with huge amount that those, particularly the standalone clinics and all, they are so frightened that they will immediately like to settle. The insurance companies are telling that get insurance from us, we will help to settle also, and sometimes we will pay. So you have to understand what is the gravity of situation. Expert opinion is very important. Junjunwala case, again, they have very clearly mentioned in Supreme Court that if an expert opinion is if a surgery is done, and if you have done, if you have got a complication and your things have got worsened, then that is not a negligence. Negligence means you have done something which you should not have been doing, or you have done something which was needed, you didn't do it. Whatever is the reason, and if because of that action, if the resultant damage has been done, then you become liable. That is the expert opinion. So there are 5 Ds: duty, dereliction of duty, damage, which is direct, foreseeable, and direct causation. This is the link. If you break any of these, then you are case for negligence. So you have to fight it out. Now most of the doctors, they don't know the law, so they depend on the lawyers. The lawyers interact with another lawyer and they just carry on the case for long hours. If you know this, you strictly go and you be part of every case whenever there is a case against you, and speak on this language. And Supreme Court judgment, it's very difficult then for them to say anything against.
Yeah, absolutely. Thank you, sir.
And one important thing about expert opinion, see, expert opinion is the discretion of the court. So what happens is you have a very tight case and you ask for an expert opinion. The consumer forum especially will say, no expert opinion. Let us see the facts of the case. And if it is required, we will allow you an expert opinion. And only then you can file an expert opinion. That is one, a block as far as expert opinion is concerned.
With this, Supreme very clearly, that's why I said October 2024 judgment PGI, that you have no business to decide about what
Absolutely.
is the prognosis and how the damage is done. Even if you see that there is a problem in patient's eye, the vision has gone down, you have no business. It's an expert to tell you.
Markandeya Kadju also, yeah, there is another one. Markandeya Kadju judgment also is there.
They have
That's
spoken
true,
like this
that's
in
Yeah.
October 2024.
Because they are in no position to interpret.
Judgments with
Yes,
the,
sir.
in fact, I have been teaching the lawyers there how to fight for last 7 years.
Yes, absolutely.
Very, very good, sir. Thank you.
So, yeah.
Your opinion on Avastin uses, because there are two contradictory judgments.
I know it is. I can't comment, but there both sides are there.
Because judges are human beings, you know.
How they interpret it is different. That there is actually, but you understand that 5 or 8 years back, this was not the situation where we could have defended more that Avastin is sight saving. Now we have other options and gone. Why should you use Avastin is the question, unless there is a definite, probably in ROP, I think there is a, as per the literature also, there is a benefit. All other diseases, why should you use Avastin if the court asks, you should be able to substantiate.
Mahesh, it's not just Avastin. There are a lot of other drugs which are actually standard of care. But if you look at the vial, it is supposed to be IV only. Like, for example, fortified antibiotics for corneal ulcer.
Absolutely, absolutely.
So, how will we go about that? It's standard of care, but it's off-label.
There are
Mitomycin,
So,
mitomycin, 5FU, everything. It's off-label.
so that is
The society has to come out with those conclusions.
actually, sir, in
This, as a society, we confirm that these are the agents used in ophthalmology and we endorse it.
in our state society, we are conducting a program for legal literacy among doctors.
Very important.
Every district club, they are having talks and other guidelines. We help them to write the reply and everything, even though we don't have the right to go to the court, especially in civil court. And another thing,
Mahesh is the president of KSOs right now.
so another thing is, do not tamper with the documents. That is another important thing. Now, this is not like 10 years, 15 years back. Now, the moment they sign, they will take a photo. Okay, they will take a photo in the mobile. Then later, if you add end of endophthalmitis or something, it is all tampering. Once you tamper with the document, you have no right, because this thing is extremely dangerous. Not like olden times. I don't know. You know, one judge, there was one squint case against one doctor. That patient took the file, and they have not taken the consent. The doctor has not forgot to take the consent. Patient took the file. Immediately they understood that, and they complained in the police saying that the file is missing. And then the file came back. And it went to the court. IMA did the this thing. And the doctor said, I had the consent. Somebody took the file and removed it. So it was against, I mean, these sort of things cannot, not routinely, but so don't tamper with the documents. That is, and sign the consent, doctor himself and witness. There should be 2 witnesses, ideally not related to the hospital or patient. It is unlikely. At least some staff or some relatives, somebody. So that is. Any other comments?
Sir, the case you are referring was Ramchandra Agarwal versus Regency Hospital and others. That is the case you are referring to?
The October case is PGI Chandigarh, and this is Dr. Sood. I think Dr. Sood is there, and he operated, then he left practice. That is the case which was decided in October, and NCDRC decision was reversed in Supreme Court. So that was very clearly they mentioned that NCDRC has no business to comment
Interpret the findings.
interpret all these things.
Absolutely.
And they should have not done this thing where they organized that Itna Life Cities should be doing. This is not, absolutely the clear terms they said. It's the expert opinion to decide whether there was a negligence or not.
We should.
Besides this, there are a lot of other. Chandrajani Akhari case, there it is clearly written that even the opinion of a doctor is not sufficient, he has to be expert in that field
Exactly.
to give an expert opinion.
Correct,
So if I give an opinion on ICL and I'm not doing ICL, I just write down patient, this is not done, this is not proper, and perhaps artificial, additional lens should have not been done. So my opinion, no value. If I've been a regular ICL surgeon and I give an expert opinion that this surgery was wrongly done and this was the thing that we have seen, then that will be considered an expert opinion. So Chandarani Akhari clearly said that even the MBBS doctors, they said opinion about a kidney specialist that a transplantation, but they have no business to say because they are not expert in that field of kidney transplant. So that is very important. And Jhunjhunwala case very clearly has mentioned these things. Kusum Batra, that case is already established that in the 10th point in this thing they have said that the doctors, particularly the standalone clinic, should be guarded against those extortionists who will take a lot of money from them. But that thing has started from there at Batra Hospital at that time. And they have clearly mentioned. So you have to mention that these are the extortionists. There are extortionists also. And there are persons who will settle out of court. These are kind of things they will try to, and they will publish stories. In my case, they got the judgment in favor for loss of sight for a 6x6 vision where there is a expert opinion that there is no negligence by Guru Nanak Eye Hospital, Guru Nanak Eye Center. And overridden this opinion because that judge was retiring and the other person, lawyer, gave them a job there. And I know all these things. When I met judge personally at State Commission, that for 17 years the case has been running. They said that there's no negligence. Why in one day in a closed chamber the judgment has been pronounced with 8 months of keeping it reserved. Again a Supreme Court judgment has come that after 6 months, if any judgment is pending, it has to be changed to separate branch, separate bench.
Correct.
You cannot reserve it for such a long time. And then the judge was telling me, why didn't you meet me? I said, why you have given this kind of judgment and all? Oh, I'm so sorry, I didn't see you. I didn't met you earlier. You should have seen me. I have kept judgment 8 months. Like this, is happening in the Supreme Court Bar Association advocate. I met all the top advocates and they charge 15 lakhs rupees for one sitting. One standing in one time they will charge for appearance. And there are 100 appearances. So what is happening? It is totally, people are not understanding that how doctors are kept like that. And the extortionist group, all big persons. Supreme Court judge, daughter is coming against me, talking about. How dare they say that there is a loss of sight when there is nothing? Now, the NCDRC, when it came to NCDRC, I said that first ask them opinion on sight. So say they refer to AIOS report get 6x6 vision, both eyes. Now I fought in March and the still judgment is pending.
So I have a question. The witness regarding the consent. So witness can be from our hospital side, or it has to be from the patient side only?
There should be two witnesses. One can be from patient side and other from the hospital. That is what we practice. Ideally, theoretically, it should be both outside. Not possible. Who will we get?
The question comes in cases of.
Taxi stand or something.
It's not possible. So one related to the patient, one doctor, and one staff from
the problem comes in cases of camp cases. So we do operate around 30, 40 cases a day, and now they don't have anybody with them. So
there should be a camp coordinator.
So camp coordinator is generally from the hospital side.
Probably
camp coordinator is from the hospital itself. He's the person who manages
you can get to the patient and the relatives. The camp coordinator who has some direct contact with the patient.
That's all. One doctor, one sister, one camp coordinator, and patient.
Or something for the camp coordinator.
No, sir.
When he goes to your
These
place,
are all
build a rapport,
things
he will have
that
some
we
local leader
come
there.
to.
So that leader
See,
never comes.
face
Just
only when
patient
we-
comes and a camp
all
coordinator
those
comes
things
and
don't matter, but when a problem comes, all these things will matter. The routine case, then nobody is bothered.
After
When a
complication.
problem comes, everything matters.
The doctors should be aware of the law.
Yes.
Exactly.
They can fight, and they should not depend only on their
Lawyers, they should not.
They should be present during the case because that can harm so much.
So this course is done so that you should know all these law where you can all these judgments. which you can quote in your, whenever you face a problem. Yeah, that's.
No,
Ideally,
you can say this is my signature. So if you can say this is your signature.
But ultimately, it should not go for forensic examination. Ideally, you should have write the, the name and date and everything. Somebody will write the date. You can sign fully, everything, because we are very. We don't have time for all these things. Only when something happens.
You need the full signature. Huh?
You can put initial. If the patient says that this is not your signature.
No, finally, you should say this is my signature. That's all. Initial or whatever. And this is my signature. That's
So,
okay.
sorry for interrupting. One recent judgment, I forgot that, from Pune that was, there, the patient said that this is not my signature on the consent form. So, what the legal they are advocating is thumb Aadhaar based, biometric based.
No, actually. Thumb, if the patient is illiterate.
Not thumb, sir. The whatever biometric consent. Electronic just like we authenticate our Aadhaar card with the thumb, like that. So I just inquired with the IT people. They said that it will cost around 1,000 rupees. And 1,000 rupees, and they said that for every cataract surgery, the moment he comes, you take this thumb so that it will get printed on that consent area. Consent, whatever area. Signature also will be there, thumb impression also.
Maybe we are not practicing.
It happened that people are having short signature and long signature. Not everybody is signing the same as a bank signature or a passport signature. So when you are a short signature, you just refuse that it's not my signature. It has come in a commission case where they have said that it's not mine, and they have given a handwriting expert opinion.
Forensic.
Handwriting expert opinion is available for 3,000 rupees for false.
Yeah, false.
They say that yes, it is not your signature, so he says that it's not my signature. And he is comparing it from where? From his passport signature. Now, you have not seen the passport, so there has to be, this is a very weak area where the judge can always twist. He can say, yes, he is saying that he is such a person and he will not complain, he has suffered, and he is saying that it is not his signature. You have not given the consent. For that consent, negligence is not there, but consent deficiency of service.
Consent, yes.
It's deficiency of service for which you can be charged. There is a cause called medical negligence, that's called deficiency of service. Deficiency of service in a medical case is called medical negligence. But deficiency can be irrespective of the damage that you have suffered. Irrespective of. Damage could be a complication, but if it is a deficiency that you have not got the signature, consent form signed, this is also a deficiency. So they can charge you. There is no specific thing that I could see still. We have to trust and believe. But only thing is relevant. There were 4 affidavits in favor that yes, this consent was done in front of us by the hospital staff. In spite of that, the State Commission did not bother about it. Then in higher, we don't know about it. But this is a case, how case can prolong.
And when the consent is taken, if it is taken on the day of surgery, I'm under stress, I did not properly read. So many times they come for counseling only, they take the consent. That is also another aspect.
Video consenting is accepted now. Just like EMR is accepted, video consenting is accepted. Actually, there is a judgment which quoted video consent recently for cataract surgery in camp and all. Somebody was telling.
Big setups, lot of people are doing video.
Yes, it is accepted.
They don't want all this thing. In big setup, there are always extortionists ready to take a thing, they get one thing and they can publish story.
So video consent is accepted. So we are just reaching time. Anything? So I think thank you very much for attending this thing, and I thank sir for the contributing.
All the valuable inputs.
All of us learn from each other's experiences, and we have to learn from. Yes. Thank you, sir.
Thank you very much, sir. Thank you.